So for our next presentation, I'd like to introduce my colleagues, Paul Saunders and Patrick Haynes. Paul serves as the Williams Mullins Ethics Counsel, as well as offering ethics advice and counsel to clients outside of the law firm. Paul also focuses his practice on a range of corporate matters, including secondary mortgage market purchase and sale and securitization transactions, trust preferred securities transactions, project finance transactions, including PURPA qualifying facilities, and exempt wholesale generators. Patrick is a member of the litigation section at our firm and serves as the co-chair of the white collar and investigations team. He focuses his practice on handling all manner of disputes that arise from business competition and regulation. His practice has included a broad base of civil and criminal litigation at both the trial and appellate levels. He also acts as a deputy counsel for the firm. Paul and Patrick, take it away. Patrick, it looks like you're on mute.
Okay, can you hear me now?
Yep, all good.
Great. Well, let's begin with the, let's jump right into case one. If you can do the next slide. Our first scenario is this. During the 10 years that you practiced in a private law firm, you handled numerous real estate purchase and sale transactions, including at least 3 transactions in which your clients purchased former commercial sites from Pharmaco, a large drugstore retail chain. Last year, you withdrew from your law firm and joined the in-house legal staff at Pharmaco. Now, you've just learned that your former law firm is representing one of your former clients in a breach of warranty claim against Pharmaco over asbestos contamination at the property that Pharmaco sold to your former client in the transaction that you handled. So the question here, and we're going to have our first poll, if we can bring up the poll, and everyone, please answer this to signal your participation. Do you have a conflict of interest if the general counsel tasks you with working on Pharmaco's defense in this matter? So we're going to wait enough time to get for everyone to have their opportunity to answer this question on the poll. Let's go about another 10 to 15 seconds to give the final participants an opportunity. All right. Well, let us end the poll. And as you can see, we have a substantial majority saying that, yes, you do have a conflict of interest. Paul, what say you?
I say the majority is correct. What we're dealing with is the application of what's known as the former client conflict rule. It is Rule 1.9a. A lawyer who formerly represented a client in a matter will not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the former client's interests, unless the former client gives informed consent in writing. So the first question to consider in this analysis is whether the real estate purchase, the prior purchase and sale transaction, if you will, in which Pharmaco sold the property to the plaintiff, is it substantially related to the breach of warranty claim against Pharmaco? Comment 3 to Rule 1.9 provides some gloss in determining the meaning of the word substantially related. Matters are substantially related if they involve the same transaction or legal dispute, or if otherwise there is a substantial risk that information that normally would have been obtained in the prior representation would materially advance the client's position in the subsequent matter. Basically, the concept of substantial relatedness was developed by the drafters of the model rules as a proxy. The concern ultimately is the information acquired by the lawyer and the representation of the former client in the previous transaction. And what is anathema is that that information could be used against the former client. Instead of putting the former client to the choice of objecting to your subsequent representation by disclosing what the confidential information is that they're concerned about being used against it, they came up with this substantial relationship test. Basically, if the matters are substantially related, then under the rules, there's an assumption that the lawyer acquired disqualifying information. That is, information acquired in the prior matter that would be material to the lawyer's representation in the subsequent matter adverse to the prior client. Now, in this case, the reps and warranties that Pharmaco made in the real estate purchase and sale agreement you negotiated are going to be a central issue in this breach of warranty litigation. And it seems to me beyond doubt that the two matters are substantially related for purposes of Rule 1.9. So you have a conflict of interest. Interestingly, particularly because this is no longer a transactional matter, it is a dispute, you're likely to find that the former client plaintiff is unwilling to grant a waiver.
Yeah, and no surprise there. They wouldn't want to see their own lawyer who drafted the provision then be on the other side and attacking it. It comes to me that in a lot of cases of conflict, and this is a great example, the substantial relation test is essentially embodying the duty of loyalty and the duty of confidentiality. One, you can't be on both sides of the dispute of the same provision. And second, that you can't, that the substantial risk, as you described, test really prevents the lawyer from being in a position where they could use confidential information from a client against that client's interest.
I think that's right. It also, I think we should recognize, is an easier standard for the lawyer than the what's called the concurrent conflict of interest rule, which is Rule 1.7. There, it matters not whether your representation of the other client was in a substantially related matter. Even if it's wholly unrelated, you would have a conflict of interest being adverse to that client in any matter.
That's right. So let's move on to case 2. And if we can go to the next slide. You are, in case 2, an associate general counsel at Devco, a real estate development company. 10 years ago, before joining the company, you were partner in a local law firm and together with your colleagues represented Sherman Paint Company with respect to its facility in an industrial section of the city. Testing has revealed the existence of an underground pool of toxic substances deep beneath the facility. The contamination likely resulting from the use of neighboring property over 70 years before. Ultimately, your environmental colleague concluded that Sherman Paint had no remediation or reporting obligations with respect to the contamination, and that representation was concluded. Subsequently, Sherman sold the facility to Jackson Supply Company. Now, Jackson Supply wishes to sell the facility to your employer, Devco, and the president of the company has asked that you handle the transaction from the negotiation of the purchase and sale agreement through closing. So let's do the second poll question involving your prior representation of Sherman Paint. Is there at least a potential conflict of interest because of your prior representation of Sherman Paint? We have the answers quickly coming in. Let's wait about 10 more seconds. And see if we get a few more. All right, let's close the poll. The answer, the majority poll answered here, yes, 82%. there is at least a potential conflict of interest because of your prior representation of Sherman Payne. What do you think?
I think that most of our audience is ethically attuned today. The answer is yes. We're dealing here with Rule 1.7, the concurrent conflict of interest rule. And we're dealing with the section that, in my experience, tends to come up, or conflicts under it come up less frequently. We're used to situations in which you seek to represent client A in a matter that's adverse to another client. So it's a representation directly adverse to another client. Here, the second type of concurrent conflict of interest arises, sometimes called a material limitation conflict. That is where the representation of a client may be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by the lawyer's personal interests. Now, you had obligations under Rule 1.6, the confidentiality rule, to maintain the confidentiality of information you acquired during the prior representation of Sherman Payne. And that would include any information that you acquired during that representation regarding toxic contamination underneath this property. There is no time limit on your confidentiality obligations. At the same time, if you undertake the representation of your employer in this acquisition, you have a duty to be zealous within the bounds of the law in doing so, which would include using any available information you have to advance your client's interests. Information about this contamination is, the written material say probably, I would say absolutely material to DevCo's acquisition of the site, in the sense that it is, I think, a foregone conclusion that DevCo either would be unwilling to purchase the site after learning the contamination, or if it were willing to go forward, would do so on different terms: more substantial seller reps and warranties, indemnification by the seller, similar provisions, different terms than it would if it did not have that information. And I think that is a hallmark of what is material information, at least as to the second representation. There's a helpful legal ethics opinion issued by the New York City Bar Association 17, 18 years ago. And it analyzes the different issues in the best way that I have found in any of the authorities. As a first matter, a lawyer has a duty to use any available information to advance your client's interest, but that duty is qualified by the duty of confidentiality she owes to her other clients. Second, a client has no legitimate expectation that a lawyer will use the confidential information of another client for the first client's benefit. You have no right to anybody else's confidential information. And third, the lawyer does not have a duty or even the right to disclose to one client the confidential information of another client. Now, notice when we talk about confidential information, it's not just information that we would normally consider a secret. It's any information you acquire in a representation, because you're required to keep it confidential. This bar opinion posited two tests to determine whether the lawyer in this situation has a conflict. The first is what is known as the materiality test. There are situations where information the lawyer has in his or her mind from the first representation is so material to the second representation, the lawyer cannot avoid using it. In that situation, the lawyer can be said to represent differing interests, in the sense that representing one client cannot be accomplished without violating the rights of another. Alternatively, the lawyer can be said to be unable to proceed because continued employment will mean violating a disciplinary rule. The confidentiality requirements of Rule 1.6, that you cannot use a confidence or a secret for the advantage of another client. The second test is known as the independent professional judgment test. Question is, is the lawyer's exercise of independent professional judgment, exercised zealously in the interests of the lawyer's client, or is it likely to be adversely affected by the lawyer's possession of the information and restriction on its disclosure or use? The danger is that the lawyer may steer so far clear of disclosing the embargoed information that the lawyer will not pursue other avenues that another lawyer might pursue to obtain the information. For instance, the lawyer might not recommend a course of conduct that he or she otherwise might, or not investigate a situation for fear that the impetus was tainted by the confidential information. And the lawyer would want to avoid any subsequent allegation by the former client that you traded on information that you learned in your representation of me. There's an equal danger in the sense that the lawyer may err on the side of steering the representation of the company in a way where he is certain to discover the information he already knows about contamination under the property. In that sense, he would represent the company differently than he would otherwise because he has this knowledge and would attempt to discover it in another way, shall we say. I think in doing so, he is trading on the information he has acquired in the first representation and therefore breaching confidentiality obligations under Rule 1.6. Now, in this case, the confidential information acquired in the prior representation of the paint company would not be material if it would be uncovered in the ordinary course of your representation of the company in this acquisition, unless it's important for the company to acquire the information earlier than you would normally obtain it in the ordinary course. Since you typically urge any purchaser of industrial property to conduct phase 2 environmental testing as part of its due diligence efforts, and as that testing would disclose the underground information that you already know is there, your possession of that information in advance isn't likely to affect your representation of the company. Again, unless it's important that the company obtain that information sooner than you're likely to get the phase 2 testing results. I should note that this is one of the more difficult kinds of conflicts that lawyers face because it's so difficult to determine that you have a conflict. Mm-hmm. There is no system, there is no software that's going to red flag this representation for you. You are wholly reliant on your memory of your prior representation and a bell going off in your mind, hey, this might be problematic. I need to bring it to somebody's attention. Thankfully, this sort of conflict doesn't come up often, but when it's done, when it is, it's particularly difficult to deal with. The reason is, in all likelihood, the conflict is unwaivable. The reason is you can't make the disclosure of the information necessary for the client to understand what it is it's waiving. I know something material about this property. You really would like to know it, but I can't tell you, really isn't adequate disclosure. And so any waiver obtained based on that sort of limited disclosure is ineffective anyhow.
Yes, it also occurs to me that the other possible solution is getting Sherman companies, at least conceivable, get their consent to share the confidential information that you gained in the prior representation. But again, in order to get informed consent, you would have to disclose to them that the reason is you want to represent it or share it with a potential purchaser of the property. Now, perhaps they could be reassured under the state's law that there's no residual liability upstream back to Sherman Company, and thus waiving it would do them no harm. But that's sort of an extreme hypothetical, it seems to me. Well, more importantly, let's talk now about, because you mentioned the difficulty of not having a conflict system in place to catch this. And that's something that jumped out to me about our case 3, which kind of takes this scenario and goes to another level. Let's assume the same facts as in case 1 or 2, but either one of which we've identified a conflict of interest for in-house lawyer based on their prior representation out there working for a law firm. Would the general counsel at Pharmaco or Devco, as the case may be, or any of your other colleagues in the legal department of your current employer be able to represent the company in the breach of warranty litigation or in the real estate acquisition without the conflict arising from your prior representation or from the knowledge that you obtained during your prior representation of Sherman Paint? So let's put up our third polling question. So this takes either of scenarios 1 and 2 and basically says, can other lawyers in my legal department handle the same matter? All right, we'll wait 10 or 15 seconds. Most of our respondents are concluding that general counsel or other colleagues would be able to represent the company in the breach of warranty litigation or the real estate acquisition without the conflict arising from your prior representation. And let's close the poll. 84% gave the answer of yes. Paul, how would you analyze this question?
Unfortunately, the answer is no here. The conflict of interest is going to be imputed to all of the other lawyers in your office. The reason is what's known as the imputation rule, Rule 1.10. While lawyers are associated in a firm, none of them shall knowingly represent a client when any one of them practicing alone would be prohibited from doing so by the conflict rules 1.7 or 1.9. You might argue that this rule by its terms applies to law firms and not to the in-house legal staff of a corporation that is not a law firm, but that doesn't work. Under Rule 1.0, the terms firm and law firm are defined as follows. A lawyer or lawyers in a law partnership, professional corporation, sole proprietorship, or other association authorized to practice law, or lawyers employed in a legal services organization or the legal department of a corporation, government entity, or other organization. Comment 2 to the rule fleshes it out. With respect to the law department of an organization, there's ordinarily no question that the members of the department constitute a firm within the meaning of the rules. There can be uncertainty as to the identity of the client. For example, it may not be clear whether the law department of the corporation represents a subsidiary or affiliate, as well as the corporation by which the members of the department are directly employed. And a similar situation can arise concerning an unincorporated association and its local affiliates. Comment 3 to Rule 1.7 should also be noted. It requires that lawyers and law firms adopt reasonable procedures appropriate for the size and type of firm in practice to determine in both litigation and non-litigation contexts the parties and issues involved. So in-house legal organizations are required to adopt appropriate procedures to identify conflicts and potential conflicts. In this case, you've brought your conflict with you into the in-house legal department and it's infected everybody else.
Right. Which is a reason it's important for in-house departments similar to law firms to when you're onboarding lawyers who you're hiring who have been in private practice to obtain some basic information if possible without breaching your obligations to your clients about prior representations.
That's right.
All right. Well, interesting. And I think a lot of our discussion today will raise some interesting questions about that in the context that in-house law firms have, or in-house practices have the same imputation rule indistinguishable from law firms. So let's go to case 4. In case 4, you are general counsel at Bosco, a food processing company, and you have an opening for a lateral hire after the recent departure of a seasoned litigator in your office. A young litigation partner at a law firm in the region has contacted you about the position. After a round of interviews, you and your assistant general counsel agree that she is just the person you're looking for. You ask her for the information that you'll need to run a conflicts check and discover that she previously performed a limited amount of research in connection with protracted commercial litigation between Ajax Company, her firm's client, and your company, and that her work on such matter has concluded. You and several other in-house lawyers at Bosco have been involved with outside counsel in handling that same litigation. Now, survey question number 4. Would hiring the lateral candidate pose a conflict for you and your staff? Would hiring the lateral candidate here, who previously did a limited amount of research in the litigation matter between your company and Ajax, would hiring that candidate pose a conflict for you and your staff? All right, this one is much more even, I think, as we've started to appreciate the application of the law firm definition in Rule 1.0 to these scenarios. As you can see, now we have much more evenly divided response. Yeah. All right, let's close the poll. I think 96% is about as much as we can get. Those 2 waverers will be able to add their answer after they've heard it. So, Paul, what do you think?
The answer is yes. Hiring her would pose a conflict of interest. And it might disqualify you and your entire in-house staff from representing Bosco in this litigation. An ethics screen alone is insufficient to cure the conflict. You'll need waivers from Ajax and from Bosco if you hire the lateral candidate. The conflict issue arises under rules 1.9 and our old favorite 1.10. 1.9 A and C provide a lawyer who formerly represented a client in a matter shall not thereafter represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client. And a lawyer who has formerly represented a client in a matter or whose present or former firm has formerly represented a client in a matter shall not use information relating to the representation to the disadvantage of the former client or reveal information relating to the representation except as the rules would permit or require. Comment 4 describes competing considerations that inform this rule. First, the client that you formerly represented, your prior client, must be reasonably assured that the principle of loyalty to the client is not compromised. The rule, and second, the rule should not be so broadly cast as to preclude other persons from having reasonable choice of legal counsel. Third, the rule should not unreasonably hamper lawyers from forming new associations and taking on new clients after leaving their former law firm or employer. In this connection, it should be recognized that many lawyers practice in firms, that many lawyers to some degree limit their practice to one field or another, and that may move from one association to another several times in their career. As it notes, if the concept of imputation were applied with unqualified rigor, the result would be radical curtailment of the opportunity of lawyers to move from one practice setting to another, and of the opportunity of lawyers to change counsel. The lateral candidate would have a conflict if she joins the Bosco in-house legal staff and works on the Ajax litigation for Bosco. That would constitute switching sides in the same matter.
Mhm.
It is irrelevant that her involvement on the other side of this litigation was limited. That she was involved at all is enough to trigger the conflict. Even if she were screened from the representation in this litigation and neither participated in the representation nor shared information with anyone else on the in-house legal staff about her former representation of Ajax, the conflict remains. This is an important point. To my knowledge, the Virginia Supreme Court, and I suspect the North Carolina Supreme Court as well, but the Virginia Supreme Court has had 3 different occasions in which the bar recommended modifying the conflict rules in certain circumstances to permit curing a conflict with a screening device of some sort and without waivers. And in each case, the Virginia Supreme Court rejected it. And that is certainly the position in North Carolina as well. So screening alone is fine and good. And in fact, you may decide to screen as a condition of the former client granting the waiver here.
Right.
It's undoubted that the former client will always insist on that screening to ensure his confidential information is protected. But a screen alone is insufficient. There must be waivers. Now, Rule 1.10 says that while lawyers are associated in a firm, none of them shall represent a client when the lawyer knows or reasonably should know that any of them practicing alone would be prohibited from doing so by the conflict rules. In this case, the conflict will follow the associate to your company, will be imputed to you and all of the other lawyers on your staff. The only way that you can thread the needle in hiring this litigator and avoiding disqualification is to seek and obtain waivers from Ajax and Bosco that would waive the conflict, and to do that before she begins work on your in-house staff. Now, as I say, the waiver from Ajax undoubtedly will require that the new hire be screened from participating in the representation of Bosco and from sharing information she gained during the prior representation of Ajax.
Yeah.
And if Ajax refuses, then she can't come to work for you.
Right. All right. Well, let's go on to a case that assumes the same facts, case 5. Except that instead of having previously worked on the litigation matter between Ajax and your company, Bosco, she has had no involvement in that matter. She had worked on a lease transaction in which her firm represented a lessor, Delta, and Bosco was the lessee, but that lease matter was concluded 2 years ago. You extend an offer of employment to her. Now, if she decides to accept the offer, put up the polling question, please. If she decides to accept the offer, will you or the rest of your in-house legal staff be able to represent Bosco in the pending Ajax litigation without conflict? Okay, so here our potential hire worked on a lease transaction, which was adverse, where she was representing a client with adverse interest to Bosco, the company you work for. But the lease matter was concluded 2 years ago. And again, this is not involving Ajax, with whom Bosco is currently in litigation. We are up to 94%. Let me wait 10 more seconds just to see if we get a couple of stragglers. All right, let's close the poll. Paul, if she decides to accept this representation, will the rest of the in-house staff be able to represent Bosco in the Ajax litigation?
The answer is yes, in fact, absolutely. Not only will the rest of the staff be able to represent Bosco in the litigation with Ajax, she'll be able to participate as well. This is a straight application of Rule 1.9. Rule 1.9a, if you formally represented a client in a matter, you shall not represent another person in the same or substantially related matter in which that person's interests are materially adverse to the interests of the former client. Well, the Ajax litigation doesn't involve her former client Delta at all. A lawyer who has formally represented a client in a matter who is present, or former firm has formally represented a client in a matter, shall not thereafter use information relating to or gained in the course of the representation to the disadvantage of the former client. Don't know how information about the lease representation of Delta would have any bearing on this litigation between Ajax and Bosco. Nor would there be any need to reveal information learned in the representation of Delta in the lease matter in connection with this litigation.
Right. Yeah.
So presumably she has no information that could be used to the disadvantage of Ajax in the litigation. Therefore, Rule 1.9C doesn't apply. And as she has no conflict of interest in representing Bosco in the Ajax litigation, there's no conflict of interest to be imputed to others on your in-house staff.
Okay, good.
Now,
Now, let's move on. Let's go to case 6, because in case 6, we're building on the same hypotheticals, but going back a bit. Assume the same facts as in case 4 and 5, except that the potential lateral hire here not only performed her prior research in the Ajax litigation, she actually had has had, up to when you're hiring her, a substantial and ongoing involvement in that representation up to the present. Now, question 6 is, are there other ethical issues associated with her pursuing employment with Bosco? All right, we have almost 100%. Let's give it a few more seconds. I do want to move along so we can get through as many of these as we can. All right, let's end this poll. And Paul, what other, seems overwhelmingly people are discerning that there are, in fact, other ethical issues associated with the associates pursuing employment with the company. What do you think about that?
I think that's right. A lawyer's pursuit of employment with the firm she currently opposes in a matter is deemed to, at least potentially, materially limit her ability to represent her current client. And that poses a conflict of interest under 1.782, the substantial limitation test. Now, there's an ABA formal opinion from 27 years ago, number 96-400, that stated a lawyer's pursuit of employment with an adversary firm may affect a lawyer's duties under at least 4 of the rules. The lawyer's duty to represent her client without any limitation imposed by her own interests, which is Rule 1.782. The lawyer's duty to act with reasonable diligence and promptness in representation of her client under Rule 1.3. The duty to preserve the confidentiality of information gained during the representation of her client, which might be compromised by inadvertent revelations during employment discussions with the opposing firm. That duty arises under Rule 1.6. Also, the lawyer's duty to keep her client informed about the matter and to communicate to the client facts pertinent to the matter under Rule 1.4. Now, 2 factors play in a material sense in the chance that a lawyer's pursuit of employment might materially interfere with the representation of her client and pose a conflict of interest. The nature of the lawyer's role in the representation of the client and the extent to which the lawyer's interest in the opposing firm is concrete and has been communicated and reciprocated. It's likelier a job search will affect the lawyer's judgment in considering alternatives or foreclosing courses of action when the lawyer has an active and material role in representing the client. If the status of the matter is such that there's no need for the lawyer to exercise her judgment in representing a client during her job search. The case has already been tried, it's up on appeal, you've filed your appellate briefs, you're just waiting for the appellate court to render its decision. It's unlikely the job search would affect the exercise of her judgment on behalf of her client, because there's no issue on which she's likely to be called upon to exercise her judgment on behalf of the client during this period. In the same way, if the lawyer had a limited and now concluded role in the representation of the client, there's no reason to believe that the lawyer's job search will prejudice the client's interests, notwithstanding that other lawyers in her firm continue to work on the matter.
Okay, so that's why that associate who had just done research in the AJAC litigation had no ethical issues under this interpretation, under the formal opinion, in reaching out to you at Bosco.
That's right.
Okay.
Now, on the other hand, the lawyer who is the lead lawyer in a matter, at least according to this ABA opinion, should not even contact the adverse firm about a possible association without consultation and consent from her client, because that contact may materially prejudice the client's interests.
Mm-hmm. Right.
I know, imagine that conversation with your client who's at death grips in this litigation, and you tell them, I want to talk about hiring on with the other firm that you hate so much. That conversation is unlikely to go well.
Well, and since necessarily, if you got hired by the other side, you would no longer be able to represent your client, who you would be prejudicing their interests. It's hard to see how you could even have that conversation.
That's exactly right.
Okay.
As for the point at which the lawyer's interest in joining another firm satisfies the concreteness, communication, and mutuality criteria outlined in the ABA opinion, there's no bright line rule for all circumstances. In most situations, they occur between the extremes. At one end is a lawyer with a minor and now concluded role in the client's matter. At the other end is the lead lawyer for the client who seeks to switch sides. And the ABA opinion offers some guidance. A lawyer who has an active and material role in representing a client in litigation must consult with and obtain the consent of that client, ordinarily before she participates in substantive discussion of her experience, clients, or business potential, or the terms of an association with an opposing firm. Well, that all comes up fairly early in discussions about a potential lateral move. So it really comes up at the point at which one contacts the other and asks, would you like to talk? I think at that point, you're now at a node, a decision point about whether you go forward, in which case you need to get the client's consent, or whether you defer those discussions. There are some circumstances where a lawyer who does not have any direct contact with the client, it would not be appropriate or necessary for the lawyer to address the potential conflict directly with the client. Client might not even know who you are. You're a lowly first-year associate whose only contact with this case is a couple of research memoranda. In those cases, the lawyer should first disclose the potential contact to the principal lawyer for that client, or to the lawyer's supervisor in the matter, who can then choose whether to relieve the lawyer of any further responsibility for the matter during her job discussions, or to make the necessary disclosure to the client and obtain its consent to the lawyer continuing to work on its matter. Again, the concern is that the lawyer, consciously or not, will take her foot off the gas in representing the client to curry favor with a potential employer.
Right.
By the way, the same concern arises on the other side. The firm is so anxious to bring somebody on board that the consciously or subconsciously sacrifice the interests of their client and make a matter less contentious than it needed to be. That's why both the lawyer who seeks to make a move and the adverse firm each has a decision to make about this issue and informing its client. As lawyers, especially associates, frequently, you're early on in employment discussions. Basically, all you know is you're interested in talking to them, they're interested in talking to you, but nothing beyond that. You generally don't want to tell your employer you're looking until you have an offer in your pocket.
Mhm.
The notion that you would tip your hand and perhaps color the way that your colleagues view you and your boss going forward with no certainty that this will result in an offer that you wish to accept is probably too much uncertainty for most associates. That's why when these issues come up, and they can come up fairly often, particularly in a small town, when you're talking to other firms in the same town, the decision is often taken to defer employment discussions until the matter between you and the adverse firm is resolved.
Mhm.
To the extent you have a number of issues, a number of matters that you handle over time, it requires a delicate bit of timing to find an interlude between cases where you can talk, or else this issue will intrude once again.
Yeah, that's right. Well, let's move on to case 7. We have limited time, and I want to get through as many cases as we have in the written materials. The materials are available, so if there are, as they probably will be, some cases we don't get to today, there are more materials and more of these hypotheticals and the answers to them in the written materials. Case 7, you are in-house counsel for a corporation that is a defendant in a product liability suit. You hire an expert witness to testify on the applicable standard of care. You instruct him not to have any communication with the plaintiff or his lawyer. So our poll question, number 7, is your instruction not to have communication with the plaintiff or his lawyer permissible? And I want to remind everyone that if you have requested CLE credit, you must respond to these polls to verify your attendance. So be sure to submit your response if you are seeking and have requested CLE credit. So it is coming in fairly strong, around 70%, saying that yes, your instruction is permissible to instruct your expert who you have hired not to have any communication with the opposing side in the product liability suit. We are at 94% in almost a minute. Let's close the poll. Paul, is this instruction permissible?
The answer is yes. This is a hypothetical that was addressed in a Virginia legal ethics opinion number 1787. Deals with the duty of a lawyer when providing confidential information to an expert witness. The applicable rule is 5.3a. When an attorney employs or is associated with a non-lawyer, he must take certain precautions. Comment 1 to that rule confirms that it applies not only to the employees of the attorney, but also to independent contractors such as this expert witness. The rule directs the attorney to make reasonable efforts to ensure that the firm has in effect measures that give reasonable assurance that the person's conduct will comply or be compatible with the professional obligations of the lawyer. They're not obliged under the rules, but you have a duty to make sure they comply with the requirements of the rules. The attorney in this case has provided confidential client information to the non-lawyer expert witness. The attorney then needs to make reasonable efforts to ensure that the expert witness understands the attorney's duty of confidentiality and that the expert witness protects the confidentiality of the information he's received. On the specific questions raised with this hypothetical, in the LEO inquired whether the attorney could request the witness to contact the attorney upon receipt of a request or subpoena and obtain an agreement from the witness that he would keep the client information confidential, including not disclosing the information to opposing counsel. Each of those steps is appropriate for the attorney to ensure that the expert witness does nothing to compromise the attorney's duty to protect the confidentiality of information as required by Rule 5.3. The committee consistently has declared that protection of client confidences is what is known as a bedrock principle of legal ethics.
Now that makes sense. And outside of legal ethics, of course, it's also a bedrock principle of the maintenance of the work product as a litigator, that you in order to protect the work product between you and your expert, that expert must not be sharing it with adverse parties. So the substantive law backs up or reaches the same principle. But what I don't understand is I'd always heard that you can't instruct a witness in a case not to talk to the other side.
Well, that arises under 3.4F, which says that a lawyer shall not request a person other than a client to refrain from voluntarily giving relevant information to another party unless he's a relative or managerial employee or other agent of a client. And I think the argument would be that the expert witness is an agent of the client, okay? Also, the lawyer must reasonably believe that the person's interest won't be adversely affected by refraining from giving the information. You don't want to have them charged with obstruction of justice and the like.
Got it. Right. Okay. That makes sense. Now let's move on to case 8. In case 8, you have just learned that your corporate client's CEO, in order to embellish the company's financial performance, has directed the treasurer not to book certain substantial expenses in the current year. Polling question number 8 is, do you have any duty under the rules of professional conduct? Do you have any duty arising under the rules of professional conduct when you learned that the corporate CEO, in order to embellish the company's financial performance, has directed the treasurer not to book certain expenses in the current year? Let's keep this poll question open about another 10 seconds. I know the blood sugar is low as we approach our next break, but let's see if we can get as many answers in to get CLE credit as we can. All right, well, let's close this poll. And Paul, a substantial majority, believes that you do have a duty under the rules of professional conduct, as do I. What is that duty? What duties do we have?
The principal duty is spelled out in Rule 1.13 under subsection B. If a lawyer for an organization knows that an officer or employee of the organization is engaged in action, intends to act, or refuses to act in a matter related to the representation that violates a legal obligation to the organization, or it violates the law that might reasonably be imputed to the organization and result in substantial injury to the organization, the lawyer must proceed as reasonably necessary in the best interests of his client, the organization. Unless the lawyer reasonably believes it's unnecessary in the best interest of the organization to do so, the lawyer shall refer the matter to higher authority in the organization, including, if warranted by the circumstances, the highest authority that can act on behalf of the organization is determined by applicable law.
Now, this is one of those mandatory duties under the ethics rule. It doesn't say may refer the matter to higher authority. It says shall. So we're obligated to do this. This isn't a judgment call.
And it keys back to the duty of loyalty to the client. Your client is the organization. It is not the miscreant officer or employee who seeks intentionally or not, to do harm to the organization.
So in this case, under our hypothetical, the higher authority beyond the CEO is presumably the board of directors. If assuming that its bylaws and articles are consistent with what we would expect. So then, if despite the efforts that board refuses to act, what happens then?
Then the lawyer may reveal that information outside the organization to the extent permitted by Rule 1.6 and may resign in accordance with Rule 1.16. The import of the rule is your duty to the company requires you to report up the corporate ladder. Now, this accords with Sarbanes-Oxley, enacted in 2007, which is the first major legislation to affirmatively regulate the conduct of lawyers and displace regulation by the courts. When introduced, the original version of the act did not include lawyers. Former Senator Edwards noted the omission in Florida Day. Section 7245 of the act followed and added lawyers, and it casts a wide net. An attorney appearing and practicing before the commission, the SEC, in the representation of an issuer may reveal to the commission, without the issuer's consent, confidential information related to the representation to the extent the attorney reasonably believes necessary to prevent the issuer from committing a material violation likely to cause substantial injury to the financial interests or property of the issuer or investors, to prevent the issuer in a commission investigation or administrative proceeding from committing perjury, suborning perjury, or committing any act likely to perpetrate a fraud on the SEC, or to rectify the consequences of a material violation by the issuer that caused or may cause substantial injury to the financial interest or property of the issuer or investors, in the furtherance of which the attorney's services were used. Now, SEC Rule 205.6C exonerates lawyers from a violation of Rule 1.6 for reporting out a client's fraud or breach of fiduciary duty to the SEC. A lawyer who complies in good faith with the SEC standards is not subject to discipline under inconsistent state standards as a matter of federal preemption. North Carolina State Bar Ethics Opinion, Formal Opinion 2005-9, provided that a lawyer was permitted to disclose confidential information about corporate misconduct to the SEC, even though North Carolina's rules 1.6 and 1.13, like Virginia's, prohibited such disclosure. The ABA has amended Model Rules 1.6 and 1.13 to conform to the SEC regulations. North Carolina has not amended its corollary rules. In doing so, lawyers are positioned to be watchdogs of the public companies they represent and of private companies as well under amended rules 1.6 and 1.13.
All right. Well, we have gone an hour, almost. We have one more minute, but not enough time to go on to cases 9 through 13 in the material. I do urge the persons attending today to read those, and if you have any questions about those, you can certainly reach out to Paul or I for further discussion of it. I will take a moment, I guess, to submit any questions under the Q&A feature at the bottom of your screen. We don't have very long, but if you have any, with the 1 minute we have remaining, we'll take a look at them. And not seeing any, and having come up on the end of our time, we want to thank you for joining us. You are now headed into your 30-minute lunch break, and when we return at 1 o'clock, you will hear from Miles Bruder and Zan Gormley, who will discuss preparing for the UCC Battle of the Forms.